Dear students, today we are going to discuss the customs valuation rules and regulations and act on the practices of Indian customs valuation. Basically, the Indian practices are mentioned in the new law which was passed in 1962, the Customs Act of 1962, and followed by the customs valuation rules 2007 amended in 2017, and we can find amendments in maybe in later as well. Any point of time the central government can amend these particular rules. And it is very interesting to note that India has come out with a legislation much before the Tokyo round of negotiations and the finalization of this particular act or the code, the customs valuation code in 1988 in the Tokyo round of negotiations. So, many years back India legislated upon the customs valuation and come out with the Customs Act of 1962, and which almost now we can see that most of the definitions there is a close similarity between the Indian provisions and the WTO agreement on customs valuation. So, it means that almost you can see that 20 years or almost 20 years it back India come out with rules and regulations on customs valuation, which is closely related resemblance to the Tokyo round of negotiations and later on the WTO agreement on customs valuation. So, the article which talks about the value of what is exactly the value of the goods exported or imported, and also this the export value, the tax is based on export value or import value, that is value of goods. So, section 14(1) of the 1962 Act which defines the value of goods. So, it defines the price at which such or like goods are ordinarily sold or offered for sale, for delivery at the time and place of importation or exportation, as the case may be, in the course of international trade, where the seller and the buyer have no interest. So, we discussed about the related parties, and again we will discuss about the related parties. Buyer have no interest in the business of each other, and the price is the sole consideration for the sale or offer for sale. So, value is the price at which the goods are, or the like goods or similar goods, identical goods. We will see the definitions for the similar goods and identical goods as well. So, the value is defined very clearly in the 1962 Act. So, again it says that the valuation is applicable to, this definition is applicable to exports and imports of goods. So, we come out with the first rules in 1988 after the adoption of Tokyo round of negotiations. The customs valuation determination of price of imported goods rules 1988 came in 1988 as a part of the adoption of the Tokyo round of negotiations. So, you cannot find much differences between the Tokyo round of negotiations and the Uruguay round of negotiations with regard to the provisions. So, again the prime or the first or the foremost method of calculation of customs valuation is the transaction value, and in certain cases in the ordinary course of case also it is a transaction value, and only exceptional cases this method is not applicable. So, and also the other methods which is mentioned in the Indian provisions are to be followed on hierarchical order. What does it mean? It means that all other methods, all other 5 methods other than transaction value method will be used only on hierarchical basis. Transaction value, transaction value of the similar goods. So, we will see again all 6 methods. So, these other 5 methods will be used as on hierarchical basis, hierarchical order. So, if one is not applicable, then only you will go to the other one. If already the transaction value is available, then the entire transaction or calculation of the value should be based on the transaction value method. So, the transaction value method is the method India also adopted much before the Tokyo round of negotiations. And also you can see that. So, basically it is on specific basis or ad valorem basis in earlier times, or special cases in specific cum ad valorem basis. So, the basis of valuation is basically mentioned in the act, how you are going to impose the duties and what are the methods and how these methods are applicable, all these are explained. So, as you can see that section 2C again defines goods of the same class or kind. So, we saw this second transaction method and third method, similar goods, the goods of similar goods, or you can see that the goods of the goods which are mentioned in other methods. So, transaction value method and other than transaction value. So, we will come back to all the slides in detail, and these one, and we will see the one by one the method of calculation of the transaction value or other value methods in one by one. So, here this the one more category which is included, the Indian Act, is the goods of the same class or kind. So, here the goods that are within a group or range of imported goods produced by a particular industry or a particular industrial sector, which includes identical goods or similar goods. So, the second method prescribed in the WTO valuation code is identical goods, and third is the similar goods. So, here you can see that they said that the Indian law says that goods of same class or same kind. So, the act which talks about and the rules which we are going to see in general. So, the central government and also the central the direct board of taxes and the board of taxes, which is in responsible for collecting these particular taxes, appropriate authority to fix the taxes under the particular act. And also the tariff values are fixed on classes. That is why we completed the HS code harmonization. So, for each and every product, which we can find it in the DGFT site, each and every product imported, the value or you can see that the taxes are mentioned, what is the percentage. So, and we said that the value of like products are also mentioned, notified. What is exactly mean by like products are also notified. And once the tariff value under the Customs Tariff Act of 1975 of India, then the duty cannot be paid on the basis of transaction value. That means, if the tariff is already notified under the Customs Tariff Act of 1975, that is the duty. So, if that duty cannot be calculated, it is not possible to calculate that particular duty, then only you will come to the 6 methods of calculation. So, this position was confirmed by the Madras High Court in the customs authorities versus Customs Commissioner versus Ashirvad Udyog in 2014 case. That means, once the tariff value has already been notified under the Customs Tariff Act of 1975, then there is no application of the 6 methods of customs valuation, and you have to apply the tariff value which is notified. If it cannot be calculatable, if it cannot be find out, then only you can go with the different methods. So, that means if the value is fixed under the Tariff Act, that tariff is to be applicable. That tariff is applicable to all the goods. If it cannot be calculated on transaction value, then only you will go to the like goods, and also the same level of business, or offered for sale, delivery at the same time, the place of importation of exportation, the course of international trade, all these criteria or conditions are applicable. And most importantly, you can see the seller and buyer does not have any interest. Related party transactions. Related party transactions are considered separately. So, section 14 completely gives valuation. What do you exactly mean by valuation? And then the subsequent rules in 1988, 2007, 2017, and even some amendments may be made into the 2023 as well. So, the customs valuation rules came after the WTO agreement has been signed. So, India has amended in 2007 in accordance with the new the agreement on customs valuation. So, different methods of valuation which we have discussed, 6 methods we have discussed under the WTO agreement, and under the 1988, much before the WTO, we based our calculation on transaction value. The transaction value is very clear, the price actually paid or payable after various adjustments of valuation factors and complying with the valuation conditions, and also if the customs authorities are accepted the actual declared value. So, if the customs authorities found that the declared value is not correct, then they can go ahead with other methods of calculation. And also you can see that the price is very important under the old rules. So, the price actually paid or payable for the goods when sold for export to India, that was the criteria. So, the price actually paid or payable, that means the total payment is to be made, the total payment has to be made. So, importing goods, the buyer purchased the entire amount to the seller, and also which includes all payments made as a condition of sale of the imported goods by the buyer to the seller. So, even a third party transactions, so the money to be satisfied, so the amount, the consideration to be satisfiedly paid. So, we said that India also followed the transaction value method. So, what is this transaction value? So, the 1962 Act itself defined the transaction value. So, transaction value are legally recognized. So, these transaction value which we talked about, how the valuation is made in section 14. So, it talks about the transaction value other than is related parties. So, who is the related party? So, the value will be taken for unrelated parties. So, the related parties, they are related parties. Who is the related party? So, you can see the similar languages which is used in the Customs Valuation Code and also the Indian Act. They are legally recognized partners in business. They are employer and employee. Person directly or indirectly owns or controls 5% or more, 5% or more of the stock, outstanding voting stock or shares on both the companies. one of them directly or indirectly controls the other. This is another reason. So, then they are known as related parties, directly or indirectly controlled by third persons. So, both of them control a third person. So, exactly the same weddings are used in the Tokyo round of negotiations as well. And what are the factors which is included? So, dutiable factors, commissions and brokerages, the cost of containers, cost of packaging, materials, components, parts, tools, dies, molds and similar items used in the production of imported goods. Then materials consumed, engineering, developing work, artwork, design work, plans, sketches and undertaken outside, royalties and license fees, freight charges, loading, unloading, handling charges, insurance, and some of the factors which you can see that excluded as well. For example, engineering, developing, artwork, design work, all these are non-dutiable. These are excluded as well. So, here you can see brokerage, commission, royalty, license fees, insurance, loading, unloading charges, and all these are included actually. And non-dutiable factors which you can find is only buying commission, interest charges on deferred payments. That once the goods are reach the territory of importation, then the transporting charges, installation, erection and other charges, and all the duties payable in India, all the duties payable in India are excluded from the purview of valuation. Then suspected valuation, we already talked about suspected valuation. It may be due to the related party transactions, or the invoice price is not acceptable, or invoice price is not believable, and the customs authorities believe that it is not true. Then in that case, rejection of transaction value method, suspected valuation fraud. So, transaction method is not going to be used in the case of suspected fraud. Then declared value as far below a series of contemporaneous transactions. So, the transaction value shows a very low value than the declared value of components or series of contemporaneous transactions. That means, some of the transactions shows that these are fake transactions. The customs can ask for additional information to justify the declared value, and the goods should then be valued by applying any of the subsequent methods as laid down in the valuation rules. So, we talked about the second method if the transaction value is not acceptable. So, rule 2D says identical goods. What is this identical goods? Here also you can see a very close definitional similarity between the Indian provisions and the code, the customs valuation code and the customs valuation agreement. What is this identical goods? Which are same in all respects: physical characteristics, quality, reputation. So, its reputation as the goods being valued except for minor differences in appearance that do not affect the value of goods. And also the second condition. So, same physical characteristics, quality, reputation produced in the country in which the goods being valued were produced. The same country, the same goods, alternate goods, identical goods are also produced. So, if no such goods are available, then a third person, goods produced by a third person. But other works, engineering, development work, artwork, design work, plan or sketch undertaken in India where completely directly or indirectly by the buyer, completed directly or indirectly by the buyer on the sales imported goods free of charge or reduced cost. So, then this cannot be included in the value of imported goods. So, identical goods definition also have a close similarity. So, what is this transaction value of identical goods? So, identical goods are defined. So, they are referred to imported goods that are the same in all respects except for minor differences. So, the definition we already saw, and also produced in the same country, ideally by the same person or by a third person in such cases. Then in certain cases, we already said that transaction value may be rejected. So, these restrictions with regard to in certain cases, and for example, if there are restrictions on use or disposition of the goods by the buyer, so the transaction value cannot be rejected on this basis on the following grounds. They are imposed by law or public authorities in India, limit geographical area of resale, do not affect the value of the goods substantially, the value of the goods substantially. And also, if the price is subject to conditions and the value cannot be determined, then such conditions also, these alternate methods will be used for the calculation of customs value. And also resale, subsequent disposal. So, all the adjustments can be made on the valuation factors, all adjustments can be made on the valuation factors in that case. For example, the related party transactions, unless the relationship has not influenced the price, practically it may not happen. The relationship has no influence on the price. So, if it is related party transactions, there may be an influence on the other party as well. And also transaction price can be declared rejected if the customs officer has a reasonable doubt with the accuracy of the value declared. So, declared value is very important. After furnishing certain evidences also, the officer is not convinced. That means reasonable doubt on the value of declared price, then you can go for the alternate second method. So, related party transactions we have discussed elaborately. Who is the related party and what are the different type of related party transactions. So, Rule 4 talks about, even though they are related, the transaction value can be accepted. What are those circumstances? If the sale of the imported goods indicate that the relationship did not influence the price. So, the invoice should show that their relationships are not affected the price, and then such kind of prices are accepted. And secondly, you can see that if the importer demonstrates that the declared value of the goods being valued closely and approximately to one of the test values, that is the transaction value of identical or similar goods, deductive value for identical or similar goods, or computed value for identical or similar goods at the same time. So, this also can be taken into consideration for the calculation. Then related parties. the transaction value is not acceptable in the case of transaction between related parties. So, related parties are defined under the 2007 rules, and also we saw the definition of related parties. And related party transactions in India are specifically looked into by 4 branches of the tax authorities in Mumbai, Calcutta, Chennai and Delhi. So, only on the case of related party transactions, all the the details with the related party transactions are looked after by these 4 offices. Then comes the third method, similar goods. So, similar goods are defined under section the rule 2F. So, imported goods which are although not alike, definitely similar goods not alike, in all respects have like characteristics, like component materials which do the same function and commercially interchangeable, and also with regard to quality, reputation and existence of trademark, and also produced in the same country of goods where the goods are valued, produced by the same person, produced by or same person is not making these, and alternate person, a different person. But here also in the similar goods also, so the goods engineering work, developmental work, art work, design work, plan or sketch undertaken in India were completed directly or indirectly by the buyer on these imported goods, then that connection, that goods are also, that particular charges are also not going to be calculated on similar goods. And transaction value of similar goods, like we talked about identical goods, similar goods are also defined. So, the most important part is that it is commercially interchangeable and produced by the same person or again produced by the third persons. So, similar goods, and we talked about deductive value, and rule 7 talks about deductive value. So, another method is the deductive value. So, it can be imported goods, it can be identical goods, similar goods, and the goods are come to India at the same time, and also unique price of identical goods or similar goods are sold in the greatest aggregate quantity to the unrelated sellers will be taken into consideration in the case of deductive value. So, it is in the hierarchical order deductive value. So, rule 7 which talks about the deductive value. So, goods may be valued on identical basis or imported goods are sold in India, and with some conditions, like the conditions as important at or with the time at which the declaration of the determination of values is presented. The value of such goods shall be based on unit price at which the imported goods or identical or similar goods are sold in the aggregate quantity. So, the usual cost of transport and insurance and associated costs are incurred within India are also added. The customs duties and other taxes payable in India, within India, transportation charges, sale and duties, other duties within India also is excluded from deductive method. So, here there is a list of deductions, and deductions with regard to transport, deductions with regard to insurance, and then and other duties, customs duty and other taxes payable. So, in cases imported goods, identical goods, similar goods and sold at the same time, the transaction value shall be based on the unit price. So, the first method is the transaction value and transaction value method will be adopted. The next method is the computed value method. Computed value, the name itself says, the computation consists of the sum of the cost or value of material and fabrication or other processing employed in producing the imported goods. Then definitely the amount for profit, general expenses and other areas also is. So, the cost or value of all other expenses are excluded. So, computed value. So, India developed an additional method of valuation that is known as residual method. Residual method is the value determined using reasonable means consistent with the principles and general provisions of the rules and on basis of data available in India. So, the value of imported goods cannot be calculated, then the residual method is used. But in such calculations, the value determined shall not exceed the price at which such goods are ordinarily sold or offered for sale or delivery at the time in the exporting country. That means again the buyer and seller should not be interested people, buyer should not be related parties. Then the residual method, that is the last method, is mentioned in Indian rules, is applicable. So, simply the residual method is accepting for the purposes of customs valuation two highest of the two alternative values. So, the price of the goods of the domestic market of the country of exportation is taken into consideration. Then definitely the cost of production, computed value, so and this will be added. So, minimum customs values and fictitious customs values are not going to be accepted by any country. Then there must be a declaration by both the importer and exporter. So, the importer will furnish a declaration disclosing full and accurate details relating the value of imported goods. So, that it is a strict compliance of the standards. So, this may be invoices, statements, so from manufacturer or producer, and also you can see other persons, representatives of manufacturer or producer. Then these goods are going to be a declaration to be made by the importer. So, once the rejection, so the customs officer did not believe in your declared value or there is a reasonable doubt about the truth or accuracy of the value or declared value, then such importer should furnish further information asked by the customs authorities and also the evidence to be produced. So, on receiving such information, again the customs authorities will they will calculate the customs value. So, and whether there is any relationship between or whether the parties are related parties or not. So, related party transactions are also be taken into consideration by the special offices in 4 places in India. And implementation, we know that model customs legislation is a problem. We have just amended the laws, that is all, and included new rules. And then design and deliver public education programs. So, who will provide the public education programs about the customs valuation is important, even though the education, public education is the function of every customs valuation officers, they hardly do it. training materials and update of computer systems, declaration forms, valuation databases and appeal mechanisms also to be included for the agreement on customs valuation. And then computed value have some difficulties. So, they may meet with some difficulties if on cost of production in developed countries is not provided information. Then other issues which we can find is distance from manufacturing locations, confidentiality regarding commercial costing, cost of production calculation is very difficult. Then insufficient evidences or mutual assistance programs or evidences provided by these countries. So, what kind of information they are providing, it is a concern. And capacity building in India is very important with the help of national import database and the government of India is providing. So, this will be this particular database act as a common ground. So, they will cross check with these particular prices and the import data which was downloaded. So, in general, in conclusion, I would say that the Indian Act, the Customs Act 1962 came much before the Tokyo round of negotiations and subsequently in the Uruguay round of negotiations, India passed a law with sufficient provisions much before this particular date, the act has been passed. And also, we can see that it is the role of Central Board of Indirect Taxes and Customs, they are considered to be the apex bodies on customs valuation and they are looking into these matters. And the rules 2007 and 2017 provides the rules, continuous rules for the valuation of customs. So, customs valuation is an important agreement and important agreement among all importing and exporting countries, because this agreement give you the complete valuation process. The valuation should be based on actual data, otherwise the taxes will be very high and it should not be based on fraud data submitted by. So, it should be based on actual data. So, customs valuation is very important with regard to, in India also with very regard to importation, because that will help the customs authorities to fix the correct duties and prices of the same goods. So, with this particular Indian scenario, after looking into the Indian scenario, we complete the customs valuation code, the WTO customs valuation code and the Indian provisions. And next we will go to the next the WTO agreement. Thank you.